So, Your Honor, before I turn to the specific evidence from the recent hearings that has been put together over the weekend and the—
Can I just say this? Most of the recent hearings were taken up with your recusal applications.
Well, Your Honor, you'd be surprised.
I'm sure that much more could be added.
You'd be surprised. I have some choice quotes, but I just want to clarify one important matter which I think will assist everybody in understanding the approach that I've taken in these proceedings. I am interested in demonstrating through these proceedings that a game theory model that I've been working on—
Sorry?
A game theory model.
What? Game theory? That's economic, academic.
That's right.
Theory. It has nothing to do with this proceeding whatsoever.
Well, it does, Your Honor, and I'm explaining how I've been developing a model that has to do with the distortion in the— if I may.
Sorry, can I just take you back? Because I'm trying to take some notes, typing them because I forgot to bring my notepad, but you're interested in demonstrating through these proceedings that a game theory—
So, I've been developing a game theory model, which I call the folklore effect.
The what?
Folklore effect, F-O-L-K-L-O-R-E.
F-O-L-K.
F-O-L-K-L-O-R-E. Space effect.
Folklore.
Folklore effect. Yes, and the emphasis in that model is on—
Oh, thanks.
Is on the distortion of information by entities that have obligations to preserve its integrity for.
That's all very interesting, Mr. Cooksall.
So for a long time, I've been—
It has nothing to do.
It has everything to do with this case and—
I'm not interested in your—
Your Honor, this is the context.
Make your application if you can, please.
I am making the application. I will demonstrate how it applies to this matter intimately.
Well, this proceeding is not about you trying to demonstrate some academic theory.
This is exactly what it's about. And I've been—
You might think it is, but it's not.
Well, Your Honor, let me explain how it's exactly relevant. And to clarify, for 3 years I've been under constant surveillance so I could record everything that I was doing since before the start of these proceedings, because I was picking up fights with executive bodies so I could demonstrate the effectiveness of the model. This proceeding was brought in as a reprisal to some of the things that I was doing against various people. And I have clearly documented how those things have been abused in these proceedings. I'll give you context. So, when the charges were brought against me, I was arrested, I was taken away, and I was prevented from actually enforcing my right to check whether or not a search warrant had been implemented. It is the duty of the police officers to show the residents whether or not there's a search warrant. I was prevented from calling a lawyer. Now, when I was in the cell at the time, and I was in tremendous pain from my gut attack at the time, but I created a scene at the station to make everybody uncomfortable and to have different people react to the fact that I was alleging that I was corruptly put in jail to get reactions from different people as part of the whole experiment. Because what the experiment focuses on is how people distort information when they are either ashamed or traumatized. Because—
You're trying to traumatize people.
Absolutely. The corrupt officials. Absolutely. But it's a very specific kind of trauma in the sense that it only affects people who are doing the wrong.
I find that trauma affects people's— the way—
Perception.
Perceive things and—
Absolutely.
And people's memories and viability. But that has nothing whatsoever to do with— Well, you better get to the point.
Yep. So, Your Honor, I'll give you another example of how that's been used in these proceedings on the—
Mr. Cooksall.
No, Your Honor. It's important, because—
It's just frankly bizarre.
It's not, Your Honor, because—
It's not assisting me at all.
Okay, Your Honor, if you could listen to me for 5 minutes, it'll give you some context. So, on that day, there were police officers that stood up to Joel Carswell, who was the sergeant in charge, and then he had to go on and take several steps to suppress the evidence. That evidence was discovered in communication because of what I did that day. Then, on the 3rd of May, after planning an exercise for several weeks, it was decided that I would place several police officers under citizen's arrest at the Werribee police station, and I had assembled around 8 or 10 people to go and effect that. At the last moment, Miss Sue and Ms. D. Gregorio, who were directors of, or Ms. D. Gregorio was a director of the firm. Ms. Sue is still involved in a number of entities. They thought that it would be more confrontational if I was present, so they requested me not to come, and the idea was that we would play the audio recordings that we had collected and then seek to put some people under citizen's arrest because of how they react. On the day, incidentally, the officers that they found at the station were, well, the one officer that they found at the station from the time, Miss Wilkie Burke was the one officer that we knew from the audio recording was uncomfortable with what was going on. So it was then decided that we wouldn't do that, but we would play the audio recordings and make a number of things known. Now, the idea behind that was to then generate a flurry of emails at their end, which we would subpoena later on, and we did. And that revealed a number of things about who in the prosecution was doing what Miss Carol Orfano's motive was. So throughout the course of these proceedings over the last 2 years, I have been initiating steps to know exactly what and when evidence I should expect. Now, I'm telling this now because they can't do anything. We've locked in all the data points and we know what to get. Now, with Ms. Naomi Burke, for instance, she read out her phone number in the audio recording. I know what her phone number is. I can subpoena her phone records, her personal phone records, which will show what her location was between 1:30 and 2:30. Every time someone receives a phone call, a text message, or even an update on their app, they connect to the nearest tower. Now, what we wanted to do on the 25th, I had only agreed to cross-examine Ms. McNamara because what I wanted to, and I will show you that in the transcript, but it was to get some precise information that I could use against Ms. Burke later on, and I got that information, which was when I wanted to narrow down the time for which I had to subpoena the phone records. I also knew that Ms. McNamara had, so I have profiles developed on each of these people based on everything that they've ever said.
Mr. Cooksall, so you might want to just...
No, Your Honor.
Saying all this?
No, I have this. I'm publishing a book about this, which will come out very soon anyway. So this is, it doesn't, and it's relevant to this application, and I'll get to that. Now, it's relevant to this application because this is a case where you will not have a smoking gun. What you will have is discrete bits of incriminating documentary evidence that will need to be combined all together to paint a picture. Your Honor is fundamentally ill-suited for that purpose. Based on how the proceedings have been conducted, for instance, Your Honor.
Well, you might. I'm not. You can't choose a judicial officer who is suited to your purposes.
No, but I have a right to enforce. I have a right to enforce my statutory. I have designed this. I was going to say game, but not in the sense of trivializing it. In the academic sense of my defense, based on my knowledge of all the statutory provisions. And when Your Honor partially refuses to enforce some of them.
I haven't refused to enforce.
Well, a lot of them you have, respectfully, Your Honor. But let me just point one thing out. On the 25th of March,
I'll let you speak, Mr. Cooksall. I'm sorry for interrupting you. Make whatever submission you want to make. I will rule on it.
Okay. On the 25th of March, this is the transcript that the court had provided to me. Page 213, Mr. Procedu. And it seems.
Procedu.
Mr. Procedu.
Procedu. Sorry, it's not P-R-O. It's P-O-R.
P-O-R.
P-O-R-C-E-D-D-U. Procedu.
Sorry.
What page?
Page 213.
On what date? Sorry?
25th of March.
25th of March?
Yes. 24.
Okay, you're right. Sorry. Yeah.
And it seems to me that by agreement, we do agree that first of all, Your Honor needs to rule on the recusal application. But then we would be in a position to call to witnesses. This is right after the lunch break.
So what page did you say?
213.
Just a moment, I'll just get it.
Lines 17 to 26.
Hold on, 213.
Lines 17 to 26.
Sorry, I'm having trouble locating.
May I just read them for the record quickly?
Wait, yes,
And it seems. Lines 17 to 26.
yes,
And it seems to me that by agreement, we do agree that first of all, Your Honor needs to rule on the recusal application. But then we would be in a position to call to witnesses. I'll give an undertaking that if further information or evidence emerges, we'll recall those to witnesses for his benefit. This was an agreement that I had with Mr. Porchedu during the lunch break. And I'll state for the record the specific terms of the agreement. What he had asked me was which witness, and the OPP instructor was present,
yes,
and a number of other witnesses were present.
yes,
What he had said to me, he had first asked me which people I'd be interested in cross-examining.
yes,
What he had said to me, he had first asked me which people I'd be interested in cross-examining, to get incriminating evidence so he'd have them prosecuted. And based on that criteria, the only people I'd be interested in cross-examining at this stage would be McNamara and Stevens. And now I also want to cross-examine Bridget Thomas because of the new evidence that has emerged about the metadata, which emerged in December after Your Honor had finalized the list of people. Now, I take Your Honor to another page of the transcript. This is me, and, actually, can you send me that? I'm going to read I have the extract first, which I have put in a separate document.
What page is it from?
I'm being given the page number, but I'm just going to read the extract first.
Please give me the page number if you can.
I will as soon as I get the page number from my associate, but I'm reading the part in the interim.
Just tell me.
Okay, let me.
Just tell me the page number, just ask your associate.
She's finding it, Your Honor, but may I not waste time in the interim and just...
Take your time.
Okay, no, not 28th, 25th. I'd sent this to you repeatedly. Just search for Thomas. Okay. So, Your Honor, this is page 268 on the 25th of March.
Just a moment. Let me find that 268.
This is further particularization of the agreement before Your Honor. Okay, so line 19.
Things changed, Mr. Cooksall, but...
No, there was an agreement that was never changed. An agreement is a contract. There was no subsequent contract between me and Mr. Porchedu.
All right, where do you want to take me to on page 268?
Line 19. So, what I've indicated to the prosecutor previously is that only to witnesses that are, conceivably 3 witnesses, rather, that are conceivably not affected by the disclosure of those documents at this stage are Jeremy Stevens and McNamara.
Yeah.
And also, I note, it says no, but it should be note. I wish to examine the photographer, Bridget Thomas, because the metadata that has been produced is inconsistent with the affidavit of Bridget Thomas. She's the one with those 2 witnesses. Okay. Now, let's go to the 28th of March, Your Honor.
I don't understand this.
So on the 28th of March, because now what had happened is Mr. Porchedu realized that Your Honor was not really affording me the procedural fairness that he would have otherwise expected and that he was exploiting.
Take a seat, Mr. Cooksall. Mr. Perry wants to.
Respect. The accused can't possibly talk about what someone else realized.
I'm not giving evidence.
No, I noticed. Unless he has been informed of that fact by the other party, or unless he's developed some form of clairvoyance, which...
Also, this is not evidence against him, by the way. This is a recusal application, and it's about how.
Where's your evidence about what Mr. Porcedu realized?
I'm getting to that, Your Honor. I'm getting to that.
You just said he realized. Just take me to the evidence of that.
Okay, Your Honor, this is facetious. Okay, let's say I'm alleging.
Mr. Cooksall.
This is facetious.
Mr. Cooksall, I'm going to give you another warning. I consider that to be contemptuous.
Okay.
I'm not going. I won't do anything about it at this stage, but I'm making a note of each of these contemptuous remarks that you make.
So am I.
And I will reserve the right of the court.
You can't actually do that.
I will.
You can't. By law, you can't do that.
Mr. Cooksall, I am. I'm taking note of these contemptuous remarks that you're continuously making, notwithstanding my warnings, and I'm reserving the right of the court to take action in relation to that. So,
You can't actually do that because that's.
no.
This court can only charge me for contempt in the face of the proceedings.
Well, I consider that that was contempt in the face of the court.
Yeah, but you have to do it at the time. You can't do it.
I said I'm not.
Okay. Well, then you can't use it later, because this is done in the heat of the moment. It's done based on the expressions of Your Honor. What Your Honor is saying. It would be extremely.
What expression did I give you?
Let me get this on the record. Don't interrupt.
Mr. Cooksall, what expression did I give you then that caused you to say that what I said was facetious?
It was the promptness with which, and the smirk on Your Honor's face, and the relief that Your Honor experienced when Mr. Perry took the objection. Your Honor was waiting for something. In my view, based on, Your Honor, this is what I do full time. I analyze body language. I'm writing about it. That's all that I've done in these proceedings, and that's how I've gained a lot of evidence against different people. That's how I got Ms. McNamara to bring up the statement the following day, despite the efforts that Your Honor did to impede.
I reject your assertion.
Okay, I have transcript excerpts. I
reject your assertion that I did anything to cause you to describe what I said as facetious. I reiterate what I said earlier, that I can consider it contemptuous.
This is recorded. I can subpoena the recording.
Yes, you can.
Yeah, so, what I'm saying is that Your Honor, that is not the point, whether or not.
So when you just said, then, this is recorded, you pointed up to.
The camera is recording you. I'm just pointing out to the screen that shows you.
It's not a camera recording me, Mr. Cooksall.
Your Honor, I've previously subpoenaed camera recordings from courtrooms, from this court.
No recording is being made.
Are you saying that the camera that is displaying you on the screen is not recording you?
It's not recording me.
Okay. Previously, the court will. I can provide that right now.
It's recording.
It is recording.
Can you take that off?
Sorry. Why are you taking it off? You just asked her to take yourself off the camera.
Yes, I did.
After I told you that I'm collecting evidence of your expressions, you just asked?
Normally, I'm not recorded. That's not the normal process.
It is always the process. I know the process. I've subpoenaed the recordings of magistrates before.
It's not.
Can I play them now to show you? I have them on me.
I'm not interested in that.
Okay. So, you just asked her, for the record, to take you off camera after I told you that the camera recording.
I would normally, if I'm aware that I'm on camera, I always ask to be taken off camera in court. Your Honor, you threatened to charge me with. In my view, Your Honor was complicit. Mr. Cooksall.
No need to let me.
I considered you saying several. I consider the remarks you've said today.
And I said your expressions would corroborate my.
Mr. Cooksall, please, don't interrupt. I consider your several things you've said today which impugn the propriety of me, but describe my remarks in court as facetious. I consider those matters contemptuous. I'm not doing anything about it now. I will let it go. But please be aware I'm making a note of these remarks. And you need to be aware that if you continue to engage in this behavior, there will be consequences.
Yeah, and not after you destroy the evidence. Though don't be on camera, please, and then you can charge me. I would really.
Mr. Cooksall, these proceedings are recorded, as you well know.
But you just asked her to take you off camera.
Yes.
That's wrong. I'm alleging that your expressions reveal.
I disagree.
How can you disagree?
I just did.
That's fine, but you can't destroy the evidence of it at the same time. A third person should be able to assess whether I was right or you were right. You know that the Judicial Commission of Victoria is investigating these complaints as we speak.
Because you told me normally, of course, if there's a complaint made to the Judicial Commission where there's an ongoing proceeding, the judicial officer is not notified. The only circumstances in which that would occur is, as occurred here, you told me.
Yeah, and now you're destroying the evidence.
You've lived with the consequences.
And you're destroying the evidence that the commission could have gotten.
What should I infer from the fact that you told me about that complaint?
I had to tell you because you were impeding the process of getting the audio recordings. They asked me for the audio recordings. I had to tell the court because I have to state the reasons. Also, on the audio recording form, it is a condition that I set out every purpose for which the audio recording will be used. I had to take explicit permission from this court, including Your Honor, where Your Honor is releasing the audio recordings, that I should be allowed to use them. You can continue to tell me about your game theory modeling, Mr. Cuxall, and I will not interrupt you, provided you do not continue with your contemptuous remarks. Do you understand? I'm not even directly criticizing Your Honor. I was talking about Mr. Porchedu, against whom I'm not giving evidence. I was simply pointing out the context. Anyway, what I'm saying is Mr. Porchedu, clearly, the evidence would indicate, circumstantial evidence, I should say, sought to exploit an opportunity that was created. And this is what Mr. Porchedu. So, firstly, Mr. Porchedu sought to deny the agreement had existed. That I said. It's documented.
Very good. What are you talking about?
I'm not referring to every line because we'll be here forever. The transcripts will be.
Take as long as you need.
Okay. Let me first take, Your Honor, to page 565. No, this is not the one.
While the accused is checking, Your Honor, I just wonder for the sake of clarity, and it's not in any way done intrusively. I'm quite content to resume my position at the bar table. What his stumbling block might be are informal discussions as to who he wanted called, and then a final communication to him that X, Y, and Z were available, in fact, to be called.
No, that's not what I'm saying. And you weren't there, so please.
Please don't interrupt me. I'm sure it's just unaccustomed rudeness on your part.
No, only when people are acting in a corrupt way.
Well, all I need to know, Your Honor, is whether the accused has some mistaken belief, which can be clarified.
No mistaken belief.
If he says there is no mistaken belief, then I invite him to point to specifics of evidence. In my submission, that isn't corrupt, but it is fast becoming necessary.
Okay, so, Your Honor, to clarify.
I agree.
I know you agree, but just pause a little bit. It makes it look like you thought about it first.
Mr. Cuxall, I'll warn you again. That was extremely improper. It was clearly contemptuous, and...
It was not contemptuous. Every criticism is not contempt.
To say to a judicial officer, just pause a little bit. It makes it look like you thought about it first. You're saying that is not contemptuous.
It's not contemptuous of the court.
I'm going to go off bench. I'm going to consider my position on this one.